Hello, 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 everyone. We've got a big crowd today. I'm really excited about it. Thank you for joining us for another awesome In-House Connect event. I am your IHC host, Kate Bridle, and I am thrilled to have you with us today from wherever you may be joining. Special thanks to our wonderful sponsor today, ThoughtRiver, and our fantastic presenters, Jennifer Hill and Chanley Howell, who are going to teach us about negotiating vendor agreements in the AI age. So first and foremost, please pop into the chat and let me know that you can see me and you can hear me by letting us know who you are. Feel free to put a little blurb in about yourself, your LinkedIn link, and let us know what the weather is like where you are. Fort Worth, hello. Nice to see you. I'm Kate and I am in sunny and very hot Nevada at the moment. Chanley, how about you?
Yep, Chanley in Jacksonville, Florida. Very hot and humid, but fortunately I'm inside in my office.
There you go. Jennifer, how about you?
I am actually in Cambridge, England today. Thought River is based in the UK, so I am right near our Cambridge office. I was in the upper 60s.
Oh,
So,
okay.
yeah.
Lovely. Yeah, I would take that over 93 degrees, which is low. It's been over 100. So it's a nice little break
Nice.
actually for us right now here. We've
Yeah.
got Seattle, we've got Houston, we've got Arizona, Cleveland. Hello, everybody. We're so happy to have you all here. So, if you can believe it, this is our 81st event of the year, and I want to know if this is your first time with us or if you've been with us before. And as I said, today's webinar is about negotiating vendor agreements in the AI age, and I will hand it over to Jennifer and Shanley to introduce themselves more thoroughly and get started. So take it away.
Oh, wonderful. Thank you so much. I'm so excited to be here. As mentioned, my name is Jennifer Hill. I am the CEO of ThoughtRiver, which is an AI contract review platform. And I am delighted to be here with Chanley Howell, a partner at Foley and Lardner. Before we get into a little longer intros, our goal today is really just to help you understand best practices, hard-earned wisdom, and to be able to thoughtfully negotiate vendor agreements because AI is permeating every aspect of business. We're going to cover agreements that you think about, some you might not necessarily have thought about, and go through everything, whether you are a vendor and you're dealing with clients, whether you are a purchaser and you're looking at all different sorts of vendors. But our goal is to make it easy to step into the shoes of what you need to think about for your clients, your internal stakeholders, and give you everything you need to know from the business and legal side. So I will get my slides to work. As I mentioned, I'm Jennifer Hill, the CEO of ThoughtRiver. Prior to this, I was both Chief Operating and Chief Legal Officer of Remedy Analytics, which is a health tech analytics platform that was acquired by Brown and Brown. And prior to that, I was an attorney, a corporate and licensing attorney at Gunderson Detmer and Fenwick and West in New York and California. Chanley.
Thank you, Jennifer. Chanley Howell again. I'm in Jacksonville, Florida. I practice information technology, privacy, and security law. I've been with the firm since 1991, been practicing technology law since the mid 90s when the commercial internet was born. I was always a bit of a computer nerd or a geek, but when the commercial internet took off in the mid 90s, heading to the 2000s, and there was big demand for attorneys, is when I got into it and really enjoyed it. And that obviously was a big change. And the next biggest change, or perhaps bigger change, is AI. I really have enjoyed digging into AI, both with my client work and with our firm. So look forward to speaking with you today on those issues. We'll be two lawyers talking to you, but this is not legal advice. There's no client-attorney relationship involving ThoughtRiver or Foley and Lardner, and this is for informational purposes only. A lot of content you'll be getting them or already are able to download them. Next, back to you, Jennifer.
Thank you. And just as a reminder, you can put questions in the chat. They'll be monitored by IHC as well as by us. So we'll make sure that we get as many of them as we can answered either through the presentation or at the end. So here is our agenda. We're going to start out discussing kind of what we mean by AI. Then we're going to define the scope of the vendor universe and then talk about how to get started. So before you even get to how do I think about negotiated agreement, there's actually a lot of stuff that you need to think about beforehand. That include aligning with your organization, understanding the real business drivers of whatever this transaction is, and understanding all the different steps that you need to take to build that background knowledge before you dive into the agreement. And then we will spend a lot of time discussing what to look for in an agreement and key legal concepts that may or may not come up in your vendor relationships. So AI at the 50,000 foot level. What do we mean by this? AI can mean a lot of things to a lot of people. Concepts that you may be working with very directly or may have heard of, things like natural language processing and machine learning. There are all different components of AI, and it's important to understand all of them because they may be functioning differently in the vendors that you're working with. The other bit to think about with AI is it's not just the transformation that's happening in the data that's provided by the AI vendor that you may be sharing data with in order to get an output. It is also what you are putting into it, not just for your own use, but for training data. And so thinking about these fundamental concepts is really important as we go through both the business issues as well as the legal issues that you need to think about when negotiating agreements.
And I'll speak to this. The scope of the vendor universe, Jennifer said on the last slide, it's pretty much across the universe. So we know the traditional vendors, you'll have the most obvious would be a vendor that is marketing an AI solution, either a general AI solution like a chatbot. OpenAI would obviously be one of those. It potentially could cover almost every vendor in your organization. We have a few examples here on the screen. As Jennifer said, AI has been in software since the beginning of software. It's the generative part of it that is making things differently. So think about overlooked services like billing and invoicing tools, because while a vendor that's marketing an AI solution is an obvious candidate, there are also lots of software tools and packages and SaaS services, software services that perform a function and they add in an AI element to it. Virtually every piece of software is adding in an AI element to it, some more than others. And then lastly, even vendors that are not necessarily digital at their core, like the examples we have here, health insurance, benefits administrators, facilities management, because so much business is done using the internet, even if it's a vendor that's doing where their core services may not be digital, they're going to have a portal and they're going to have AI capabilities in all likelihood.
Where does AI fit in? As Chanley mentioned, it is absolutely everywhere. So think about AI in the broadest possible terms when you were thinking about vendor agreements, both in terms of what you share, what you may be using to train, and what the output is and where it is. Because it is something that everyone is using, whether they're saying they're using it and they're directly putting it into their license agreement, or whether it's something that may be using in the background to help fulfill those services. Definitely think about it with the broadest possible view. One lens that I think is really useful is that feedback concept. So in many agreements or in many websites that you're putting in feedback, there will be something which says any feedback or good ideas or things like that that you get, the vendor gets to use that in whatever way they want. So this is like exponentially. Think about AI like feedback, but an exponential level in terms of its impact.
Yeah, and just continuing on that, every touch point with software tools, virtually every will have the ability to collect and may very well be collecting data. So browser integrations, communication tools like Zoom and Teams, the Microsoft ecosystem that probably 98% of folks on the call use, and business applications are all going to be collecting data. So as lawyers, you need to be aware of the terms and conditions. It could be a click wrap, online T's and C's type of situation. If it is, and there's no negotiation involved, just be sure that the use cases fit. We'll get into more details on the contractual terms and the use cases, et cetera. But just wanted to point out, again, consistent with the theme, as you can tell from these first slides, is that AI is everywhere.
So the first thing is to decide where and how you start with vendor agreements. The easiest thing, of course, is stuff that may be in your inbox where they are new vendors that you're working with. And so you have an opportunity to set the standards for the relationship. And a lot of the things we'll cover certainly are with that in mind. But all of the things that we're going to share also can apply to existing agreements. So one example is agreements that are up for renewal. Depending on how long those agreements have been outstanding and how often the statements of work or may not have been updated, learning what you learned today and thinking about this as you then review the agreements may cause you to ask additional questions, ask for additional clarification, or even right before your renewal, offer an opportunity for you to renegotiate some terms. So the first thing, of course, to think about is what the business goal is by entering into this relationship. What is the very clear objective that you're looking to achieve with this particular vendor? And then being able to identify very specifically where AI may or may not be a part of that objective. You may not even be thinking about it, you may not even know it's there, but at least understanding what do I hope to get out of this? What are the benefits that we're getting? And then using that as a foundation for thinking about all the different elements of the relationship. The next thing, of course, is to think through the use cases, the specific applications and functional requirements that are there. Are you using AI in several different places, or is it something that's running in the background in order for those products or services to be provided? And then with that in mind, thinking through all the different legal requirements that you normally would go through when, whatever your internal processes are, in order to then determine where you might need to think differently or more robustly about this vendor relationship, understanding that data may be collected for training, your data is being processed and may be processed with the help of third parties, and then the output that comes out on the other end, who has rights to that, and then what can you do with it?
But this slide in particular, as well as some others, have, in my view, a lot of good content. So I would suggest you take this slide and actually use it to create an outline or a checklist for when your organization is implementing or looking to implement an AI solution. It's a bit self-explanatory. I'll point out some of the important parts, but really this can be used as a roadmap. And the first is, what is the primary use case for the AI solution or use cases? That's extremely important because the type of solution you have, whether it's general AI of a chatbot nature like a ChatGPT or a Microsoft Copilot, the web version, chatbot version, or is it a point tool where like in legal, for example, there are tools designed specifically for reviewing and evaluating contracts. So what is the use case? Because you got to get the right AI for the right use case. Is the vendor using a private or a public model? If it's a public model, fine, but your uses are going to be limited because you're not going to want to put in confidential information of your organization into a public model. Even the public models have security. I would say it's decent to good, but it's not the type of risk, at least that we would recommend taking. Better to have a private model. So in real terms, that means, for example, if you're going to use OpenAI models, do it through an API and put the environment in a secure environment, like a Microsoft Azure environment. Or if you're using Microsoft Copilot, get an enterprise license and use the work mode for dealing with confidential company information. So you can see these others. How is the data siloed and stored? That's related to the security. For chatbots, is the output specifically tailored for your operation or is it general purpose? As you probably know, there's legal specific general purpose AI, there's legal specific point solutions for contracts or for litigation. So just make sure you understand the options and what you need for your particular use case. Thanks, Jennifer.
Thank you. So now that you've got all that in mind, tactically, how do you get started? These next two slides are really useful for building a business framework, and they may be something that your organization has already, but these are very kind of useful general buckets to at least go through these steps and think through things as you're evaluating what do we plan on getting out of it? What are the kinds of protections that I want to have in place? And how do I make sure that the vendor's abiding by them, but also internally that my own stakeholders are actually abiding by whatever guidelines we have internally? And the first step in that is actually identifying your internal AI and other governing policies. So presumably you've written a lot of these, or at least been part of the discussions, or you may be at the point where you're revamping those right now in light of AI. But understand what your internal guidebooks are, because that's the foundation for you not only maybe improving them in the future, but more importantly, understanding your degrees of freedom that you have with the vendor and what requirements that vendor has to meet. Things like data protection or guidelines that vendors have to meet already, definitely things to keep in mind. The next bit, of course, is understanding who your stakeholders are, because you probably have folks internally that are really clamoring to get an agreement signed and just want it done so they can get their hands on whatever it is that they have on the other side. The more clearly that you can engage with them and understand what they want to accomplish, what the requirements are, who's owning it, who's got different roles and responsibilities, All of those things are really helpful so that you make sure you're getting the information that you need in order to negotiate the best possible agreement for your organization. Now, number three, the feasibility assessment probably isn't something that legal is doing. So if other folks internally have done that, it's useful for them to inform you of it and make sure that you have the same information that they do. This is one of the many areas in which lawyers can prove so much value by thinking through not just the data issues, the financial issues, the governance issues, but sometimes it's just practically within change management. And the legal team can be really helpful to business stakeholders for thinking about the successful implementation of the vendor. And then, of course, on number four, unless you're a legal team and evaluating tech yourself, there's probably other folks in the organization, but getting a sense of how they've made their decision and why is really useful background to you. And then, of course, you've got your traditional assessment of the legal and regulatory requirements that are associated with it and how those affect things like IP rights that you have or IP rights that you might be sharing with that vendor. It's always a good idea to review your data strategy, not only where information is coming from internally, but how it's being shared, how it's then being captured and used by that vendor, and then anything that you may be sharing either just for your use or kind of like that feedback exception. What are you sharing that the vendor might be using for other purposes? And is that something that you're able to do? There can be regulatory implications. There can be contractual implications with your clients, other folks that you contract with. There may certainly be confidentiality issues. And sometimes there may just be a business decision of what to share and not share. And understanding that is super important. Security is paramount in everything. As Chanley mentioned, you want to make sure that you're not sharing things that go into the public domain. That is exceptionally important with AI. And so understanding the controls that the vendor has for cybersecurity as well as your own, mapping both of those things together is very useful. Make sure that it's done, that you're looking at the cybersecurity policies, that you're understanding things like model bias, compliance with law, that you feel comfortable with the vendor and how that vendor operates, and if the vendor is using data that they have rights to, that they're able to share for your purpose. So a lot of the things that you are probably doing day to day in your role as legal counsel, they just have a heightened awareness when you're dealing with vendors who have AI in the mix.
Great. And after you do what Jennifer just recommended, I'll talk about a couple of points on this slide, which I think are the most important. Under number one, pilot the solution. Very important to pilot it to be sure it is the right fit for you. Typically, you can get a pilot that you can conduct before you commit to a longer term production or full license. While after you go through what Jennifer explains, you should have a very good idea of what the solution provides, but as we all know, there's a lot of time big difference between demos given by the vendor and actually having your people use the solution. So piloting the solution is extremely important. Drive user adoption, and I'm going to focus on train or would suggest you focus on train users and implement change management. I've been involved in legal tech with our firm, as I say, since the 90s. And there's been no technology that's more transformative than AI, but also been no technology that's more difficult to implement and get users trained and to adopt than AI. We're in the middle of struggling with it right now, and it requires, like anything, just about anything useful and valuable in life, it takes investment. And so I tell our firm management, I tell our attorneys, it's going to take more time than you're used to learn how to use this particular application or solution. But when you put in the time, you'll also get more value out of it. Everybody's super, super busy these days, whether you're in-house or in a private practice. We trade war stories with each other, I know, outside and inside, of who's busier and who's getting driven harder. And it's probably a toss-up. But needless to say, everybody's extremely busy. But we have to be using this technology because the industry's using it. And if you're not using it, it's passing you by. So the training and the change management. And another point on that, these are tools. They're not an easy button. They're not push the button and AI works its magic and out comes your end result and you can send it to senior management or your internal client. So it just takes time and effort, but it's worth it. A few words on use of customer data for AI training. So now we're getting a little bit into your relationship with the vendor. And it'll depend on the solution. You'll need to carefully look at the terms. If it's an enterprise solution, you're more likely to be able to negotiate terms, particularly for data use. We're seeing that AI vendors are understanding much, much more the importance of data protection from the perspective of the customer. There will typically be those opportunities, and you'll typically, and I'm using the word typically a lot because you got to look at every vendor differently, but either the larger ones, the more reputable ones, they hear it over and over again from businesses and from law firms that we don't want you using our data for training the AI. Now, there's some solutions that need, that's just part of the deal. So you might have a vendor say, part of our solution is we get data and we provide back analytics reports, metrics, industry trends. And the only way we can do that is to get data from the industry, and that includes you and your organization. So if you want our product and our output and our AI, the value of our AI, we're going to have to train on your data. Now, we'll talk to you about how we secure the data and how we can de-identify the data. Typically, the vendor doesn't want your identified data or doesn't want to use you as an organization or any personal information from your employees or your customers. So that would be a topic for discussion for either de-identification before or after it gets to the vendor, and contractual protections that if something gets shared that's not supposed to, then there's consequences for the vendor. But you may have those situations where that's just part of the deal, and either you get the solution and share some data for training or you don't. So the legal terms can be in various places. In the contract, there could be a data use exhibit for a particularly complex situation that can be very granular. This would be more for a larger implementation, but also you may be getting a smaller, lower priced solution, which there's a place for those, in which case you'll need to take a look at the website terms.
Data strategy and security considerations.
Somebody said, I'm starting to see NDAs that explicitly forbid submitting any confidential data to AI systems. In theory, that makes sense, but as you've pointed out, AI is now embedded in nearly everything, so it's almost impossible to prevent some level of interaction. What do you recommend in situations like this?
Sure. Why don't I start, Chanley, and then you can
Yeah.
jump in. I think it's saying you can't share things on email or put things in Word. It is everywhere, but that's the difference. Is it put into a system where it's being processed for the other party's use, or are they using it for training? A prohibition on training is a very clear delineation. You're going to get your organization to turn off Copilot just to particularly review that. Like a lot of these provisions are not necessarily drafted with a very broad view of AI in mind. And so I think when seeing that, understanding what the prohibition is that they really care about, what is the behavior that they really care about, and then figuring out how to tailor it. Chanley?
Jennifer, I would add, and you touched on this too, if I was representing the company, a company that will be sharing information and or receiving information, let's go sharing. And I'm concerned, and it says no sharing of confidential in AI. I think the way, or if the vendor is going to use it in AI and you have that discussion with the vendor, as long as there's strong confidentiality that the vendor will not disclose your data, your confidential information, then even if it gets ingested in some manner into the to the other party system, like Jennifer was talking about, as long as you have that confidentiality obligation, if it does end up getting out, then there would be a breach of confidentiality. Second, to the extent you have these discussions with the other side, and there's concerns about that there may be, let's just say I represent the customer and the other side is a vendor, and we have serious concerns that something untoward could happen with our data, then I would need to have, and like you would have if you're in-house, we just have to be very careful with what information we share, particularly if you're at an NDA stage, a regular either software agreement or a master services agreement, you may have to revisit the whole data sharing and confidentiality.
Great. Fantastic answers. Thank you. And then just one more, and you all might not know the answer to this right off the top of your head, so please feel free to say that you don't and reach back out. But what are the data risks associated with using a paid version of Claude?
I did take a quick glance at the questions. And that's the one question I saw. And I do have an answer. It's not the answer, and we can
Okay.
obviously follow up with the answer. And I have advised a lot of clients on the T's and C's for the major LLMs, and they do evolve over time. But for a paid version, typically the answer, and I think the answer for Claude, if you look into it, the answer is it's a low risk. Now, should you put in, let's just say it's a health organization, should you be putting in large volumes of protected health information, I would want to have a serious conversation with the client before doing that. And if I could speak with someone on Claude, depending on how big of a relationship it is, maybe I could speak to the issue. I haven't conducted a security assessment for them, obviously, but I personally feel comfortable and I advise clients that they have very good security. I try not to get overly cautious on that, but I would have controls on the volume and the level of sensitivity of what I would put into the LLMs. And the larger the volume and the larger the sensitivity, I would want to be sure that I've done some due diligence and vetting on security. And also just for remedies, it's extremely common to have extremely limited remedies, but we have seen in some situations there can be some liability on the part of the LLM if there is a breach of security.
Great. Thank you so much. All right, I will hand it back to you.
The two most important points on this slide is one, make sure that you're okay sharing the data that you have, and that if that data comes from other parties, for example, your clients, that you have permission to actually pass it on. And that is entirely dependent on the contract that you have with those clients and the uses that you've already contracted with, and then how this vendor that has AI somewhere in the background is going to be using that information. Is this anonymized? Is it pseudo-anonymized? Are you making sure that there's proper security on the other side before you're sharing it? Because your concern is twofold. One, it's obviously breach of contract, but more importantly, it's losing a client. And are you doing something that could accidentally put that business relationship in jeopardy? Now, as we move on to, we've talked a lot about data going into AI. Once data is within this other vendor, what's coming out on the other side has some ownership rights associated with it, and that's really important. So one is the traditional definition of deliverables, where there's some sort of output, and obviously as the client, you want to own that. But the other bit is this concept of generated content, which is a very different definition that can be a part of deliverables, but because the generated content is what's coming out of something that has AI, this may or may not be in the vendor agreement yet, thinking about it in terms of here's all the deliverables that I'm getting, and then this generated content bit needs to be a part of it. And the reason for it is that oftentimes that generated content is going to be very specific to your organization. And as a result of that, you want to try to maximize the rights that you have in that intellectual property.
Yeah, on intellectual property rights, as Jennifer pointed out, you need to consider who owns the output. Typically, that would be the customer. That's not always the case. It can depend on the use case. But just going from the points under this point number one, the vendor's going to own the model. The vendor will own the training data that it uses. Now, if it's one of those situations where you as the customer allow the vendor to use your data for training, then you need to write in very clearly that you're not relinquishing any ownership rights to your data, that it's a limited license for the training, and that it's subject to confidentiality. And what data of yours is used to train is not going to come out for another at the other end for some other customer that's disclosing either your confidential information or your intellectual property. That needs to be clear in the agreement. Indemnification, clearly, again, from the customer perspective, the vendor should be willing to indemnify that its solution does not infringe any third-party patents and other intellectual property rights. It's a much more tricky and difficult situation for the generated output. If you're the vendor, it, in my view, is not an unreasonable to take the position that for generated output, the vendor cannot be responsible for that. One exception to that may be in the area of harmful content, as we've noted here on the slide. These days, we're seeing in the news more and more talk about in situations where truly harmful content comes out of the LLMs. And the LLMs They say they are, and I'm convinced all the ones that we hear about in the news, all the big ones are working very hard at avoiding that. It is something to consider if there's harmful content coming out, and I won't get into what we mean by harmful content and specific examples, but I'm sure you get the idea that it would not be unusual to have some liability on the part of the vendor for that. Limitation of liability, again, very fact specific. The smaller the engagement is, the smaller the value to the vendor is, the less likely there will be any significant financial liability on the part of the vendor. Perhaps carving out or excluding breach of confidentiality or breach of data security. Again, very fact dependent, depending on the amount of or the types of data that the vendor will have. The vendor may be getting a lot of sensitive data that's not used for training, but still the vendor has it on its systems. And in that case, we can think back to the pre-ChatGPT days before November of 2022, when we were talking about vendors' responsibility for storing confidential customer information. Same with service level agreements. Probably the biggest area where there will be some ability to have a discussion is on availability, 99.9 whatever percent. That it's in all likelihood going to be a SaaS solution, so you need to consider availability and what the exceptions would be.
Two quick points on third-party data considerations, because these are a big crux of things. First, make sure that if you're sharing anything with a vendor, as we mentioned before, that you have rights to use it. And then on the flip side, with the vendor, if they have third-party data that they're using to improve or embellish your generated content or that are going into deliverables, just like you would put in a clause about use of third-party data rights, make sure that those rights flow through to you. And certainly make sure that you include indemnification for improper usage.
Thanks. I would just suggest that you review this as you're working on agreements. You can use this as a resource. It has a lot of detailed information that I covered previously, and you can use it in your practice. And I'll talk about the next one, Jennifer, so we can move through some of these slides, because this one is not as top of mind for a lot of attorneys, but regulatory compliance. We have not had a lot of state laws yet. There's a handful. And there's, speaking of the regulatory compliance provision, shortly after ChatGPT came out, this, when I would talk to folks about it and talk to clients, came up is particularly anyone in New York or anyone in HR field knows about the New York City law that requires audits and disclosures for use of AI in the HR screening and hiring context to the extent AI is used significantly to make decisions. So it's important from the customer perspective to have an AI regulatory provision so that if and when there's laws and regulations that require either directly or indirectly compliance, and I say indirectly because you can take the existing non-discrimination laws that don't mention artificial intelligence all, but they're going to be applied to hiring practices and firing and other workplace practices. From the customer perspective, you would like the vendor to agree to cooperate in the event there's a regulatory concern or a challenge, because the vendor rightfully is not going to, the vendors have their technologies in black boxes and it should stay there. That's how they make money and that's how they provide their solutions. And not that they have to open up everything to regulators or to the customer, but there should be some level of cooperation in the event of a regulatory or an enforcement action.
Thank you. Quick note about bias and discrimination provisions. This is not necessarily going to apply to every vendor that you work with, but in particular, if you're using recruiting software, HR software, things like that, be sure to check state and local laws that relate to regulation around AI and bias associated. We will see increasing regulation in this area. So not only do you need to be mindful of it from a regulatory perspective, you also need to practically understand how it happens, because at the end of the day, that is something that will flow through you. And that if there is an unfortunate outcome that is discriminatory against someone, then you're going to have to answer for it. So be sure that you get very clear on what that vendor's doing, how that relates to your business, and what protections that you need to keep in place for yourself.
As far as warranties, the ones I would suggest you focus on and that are a little bit nuanced in light of AI as opposed to pre-ChatGPT, one would be regulatory compliance for the reasons I just spoke about. That's particularly important. legal standing, the fact of no litigation that would impact performance. Traditionally, this has not been a big one, but particularly if you're dealing with a larger vendor, it would not be entirely uncommon for them to be subject to litigation with respect to their LLM, or maybe analogous to the automotive industry where you might have a tier one AI vendor that's leveraging an OpenAI or a Anthropic or a Gemini. And if they're all involved in litigation, and it would be nice to have a warranty that could give you protection that if something goes bad in the litigation and you get shut off or can't use part of the service, that there's some remedy there. And then security, no viruses, spyware, et cetera, are important. AI, every technology evolution just increases the ability of the bad people and the threat actors to do bad things. So we want the vendors should keep up security to keep up with that. Limitation of liability, we can probably go through this pretty quickly. Again, to me, the significant factor on whether you can get any type of relief, while I represent both vendors and customers, it's more often on the customer side. So I'm not saying vendors should take on unlimited liability. I think it is fair for both sides to consider the value of the transaction as to the gauge of how much liability the vendor should take on. And indemnification provisions. We've talked about a number of these things. The things I look for from the customer perspective, apologies to vendors, is that it covers all of the various types of intellectual property, including privacy and publicity, because with generative AI, that's becoming more of an issue. And same for meaningful remedies. Typically, we would carve out, and vendors will frequently agree to carve out indemnification from any 12 months of fees paid type of limitation of liability.
All right. We're going to move quickly to an example about feedback, which I mentioned earlier, and why this is a critical battleground area in AI. Now, the feedback exception is something that may be in a lot of your existing agreements. And a new layer to add to it is thinking about how that information can go into AI. As I mentioned earlier, this is a very common thing that you'll see. Vendor can use customer data to improve vendors' products and services. And oftentimes we've thought about that in like information that's provided, or they're looking at logs of how often users logged onto it, or all sorts of things that in and of itself are not very difficult to see how vendor could use them to improve their services. However, now with AI, you have to think about that in terms of what information am I sharing, what output is being generated that might actually be useful to that vendor, and am I okay with that actually being a part of it? So we've got two examples. One is prohibition, and feel free to refer to this if this can be useful to take inspiration from in terms of language. One way to think about this very simple clause above is if you're granting really broad use rights, then that may include using that information to train. And that may be something that you actively want to prohibit. And there's very clear ways in which you can say that. So, for example, if I'm giving you feedback about the product and service, by all means use it, but you cannot use it to augment any sort of human intelligence development, your algorithm improvement, even if you de-identify it. This is particularly useful in areas where you have a regulated data set, such as in healthcare. That information is very valuable and you're on the hook if you misuse it. So being very sure, particularly in your existing vendor agreements, that you have things captured correctly. Now, if you are ready to give permission to use it, then think about what frame you can put around it. If you don't want it to be combined with other client data or used in particular ways, draw a fence around it and make sure that is very clear. This, in some ways, is a big part of the negotiation between your vendor and you, because your data may be really valuable and they may actually want to use it for different kinds of purposes. And so the more honest you can be with each other about how it's used and what you are comfortable permitting and why and how the results of that may be beneficial to you is definitely something to think about so that you can negotiate the best agreement that you can for your organization. Chandler, you want to walk us through an example?
Yeah, will do. This is based on a real world example where we represented a large healthcare organization and the vendor was a very large AI vendor. As I was talking about earlier, the vendor, for us to use the solution, had to have some ability to use data for training. If you think about it, it makes sense in a speech to text because when we sat down and talked to them about, okay, what data do you need and what do you need to use it for? They said these things: train and tune the solution, improve the speech analysis and translation, enable use-specific adaptation, and build an enhanced speech model. So as you can see, there's no marketing, there's no using it to build trends or data reports for third parties. It truly is to improve the product or service, and also that the data would be stored while it was in a multi-tenant environment, meaning multiple customers had their data on same machines, computers, and servers. There was logical separation, meaning software kept it separate, akin to physical separation, and it was encrypted. So we were comfortable with this situation, even involving PHI, so you can get there if need be. Now I'm going to go through a few slides. The next one, Jennifer. A lot of what you'll see on the next few slides are really for your reference as you're reviewing or preparing vendor agreements relating to AI. But consider affiliate right. These are just things on our checklist. If there's affiliates involved, what are the affiliates' rights? What are the affiliates' rights? That should be addressed. If there's a divestiture, if it's a large organization, can a divested part of the company or a divested subsidiary or entity be able to continue to use the software for a period of time during a transition period of, say, 3 or 6 months? Also, make sure your contract hierarchy, that's important as well, always has been, still is, and particularly with AI.
Yeah, and I would just say a lot of times when you've got older agreements, sometimes the way that it's just easier to override those terms is in the SOW and just adding more stuff to the SOW or adding riders to it. I found that in past practice when there's ancient agreements and technology grows so quickly and those agreements may not necessarily cover everything. So you just got to make sure that everything's in the right order so
Yeah,
that
good point.
it's accruing to you.
Yeah, you could have an SOW for software, a software type agreement, and the SOW adds a whole new, brand new AI solution in the underlying MSA or agreement, whatever it is, says nothing about AI, says nothing about training data, says nothing about who owns generated content because it wasn't a thing when the agreement was originally entered into. Publicity is particularly important when it comes to AI because vendors would like publicity, rightfully. Sometimes customers also want publicity out of the arrangement. If it's a cutting edge, innovative use of AI, both parties are going to want to make some publicity out of that. So it's a good thing to address. Click wrap terms, again, AI just adds to the complexity here because there very well could be terms, website terms and conditions are on a URL that apply to the relationship. No matter which side you're on, you just need to be sure that there's a clear understanding on how the URL terms interact with the negotiated agreement. And finally, subcontractors. As I said, there's really, in the business world, three main LLMs. So all the AI solutions you see out there, you could make that up to five if you had Meta and X, maybe five, or you could, if you want to get into China, you could get it broader. But point being, there's a handful of LLMs that are doing 90x% of the AI processing and inferencing. So that means there's a whole chain of subcontractors that are using the AI. You need to address what the vendor's responsibility is for subcontractors.
Okay, excellent. We got a few more slides to go.
Again,
Yeah.
just ticking off things that you need to be concerned about and pay attention to in your agreement. Residuals clauses, as comes up in NDAs as well as in confidentiality provisions in agreements. Data protection, we've talked a lot today about data protection. Insurance requirements, that's always very important, particularly no matter which side you're on. If the other party, it's nice to have both sides have appropriate insurance. The agreements typically will, if there's going to be insurance discussed, would focus on the vendor. And again, the criticality of that depends a lot on the size and the financial capacity of the vendor. So just keep that in mind. And then audits. I spoke earlier about regulatory cooperation, and this would go hand in hand with that. That particularly if there's a lawsuit or a regulatory audit or an enforcement action, there needs to be understanding between the customer and the vendor about how that gets handled.
This one we can These are rare where sometimes you've got, this is often from older agreements where you've got facility access considerations. I would say if that's somewhere in an old agreement, these are just things to think about generally in vendor agreements. If that is still there, who's going to go? Do you have restrictions? If you have vendors coming on site to you, how do you want them to act? What do you want them to do? And then your traditional restrictive covenants as well. Some of these are probably old school. Restrictive covenants, not necessarily, but those are always present, things to think about. Let's move to testing and acceptance because that is an important one.
Yeah,
It's a
yeah,
little
that
bit
is
different in
also
AI.
testing acceptance. Yes, very important. We touched on this sort of when we were talking about selecting and implementing a solution in a pilot. The pilot, if you have a good pilot program, that sort of can fill the role of testing and acceptance. But then again, you may either not have a pilot period or you might have a master agreement with multiple solutions being implemented over time. So in any of those situations, when you're not sure what you're getting, there should be a testing and acceptance period just to make sure that A, it works.
Vendor support
Yeah,
provisions.
Jennifer, vendor support.
Yes, always important to understand exactly what they're going to provide for you. So things like Chanley mentioned, your SLA and your response times, what the distinction is between an update and an upgrade, because those can be very different things. Think about the warranties that you want to get from vendors. Vendors obviously want to keep them as limited as possible, particularly because technology is changing so quickly. But if what you're using is really mission critical, think about just a documentation warranty, meaning that whatever they've got documented is current as of the time it's published. Think about, and then there's practical considerations beyond the legal, which is who's your project manager? What kind of relationship do you have set up with your business stakeholders? What is that communication channel like? And how often will the information that's important to you as legal counsel get to you? Things like, are they doing their security audits? Are you able to get examples of pen tests? How often are they doing all of their updates? When do they do maintenance? Just these general things to get a sense of how well they're doing their job at making sure that security and compliance is up to date because that's going to affect you. And the more you know about that, then the more you understand what you may need to put in the agreement. Do you need certain remedies for service levels? Do you need service credits? Is it so mission critical that you can only have them do updates during certain times? You'd be surprised how many major vendors do updates in the middle of the day. And if you are relying on one of their inputs, that can then affect what you're passing along downstream to your customers. So those little things matter. You may think they're all done between 12 a.m. and 4 a.m. on a Sunday, but that doesn't necessarily happen. So these are all questions to think about as you're thinking through that relationship and then what needs to be actually put in the contract.
And a great way to police that is through security assessments and requirements. For example, it could be the types of reports listed here or a SOC 2 Type 2 report where, typically, particularly these days, in all likelihood, your organization is not going to go in with your own security team and conduct an assessment. You don't have the resources. The vendor's not going to permit that. So the next best thing is to, if it is a larger, more reputable vendor, they likely will have third-party security assessments, written reports that they will share with you and you can review and take a look at to see if it's a quote clean report where either there are no vulnerabilities or there are no critical or high vulnerabilities, or if there were, they've been remedied. So that's a good way to make sure that what the contract may say and what the vendor may say about security is actually in place. Other technical considerations, we talked a bit. Oh, accessibility here. Yeah, particularly with websites, it happens more than we'd like, where we'd have a client with a website or a portal that has a remote solution and or an e-commerce site, and they get a demand letter under the ADA. Now, the ADA is extremely important, and there should be accessibility on a website. But in our experience, it's something that doesn't get enough attention from customers. So we always advise customers when we're dealing with them on their websites to make sure that it is WCAG and ADA compliant. Remote capabilities, usage limitations, there's some good information there you can take a look at. And finally, I think this is the last slide, post termination data rights. Again, very important. It can be difficult if customer data is being used and was allowed to be used for training the LLM. You're not going to get that back because when it goes into the training, just the nature of the LLMs and the machine learning, it gets ingested into the knowledge of the LLM. Now, the vendor may be retaining segregated copies of the data you provided. And in that case, the customer could get that data, but also consider whether transition assistance on other things like keeping the service available, having knowledge transfer if you're transitioning to a different service provider.
Okay. And that has gone through quite a lot about what to think about in terms of vendor agreements. We thank you very much for your attention.
Oh, yes, and there are. And I'm
Okay.
just copying another one that just came through too. Okay, hold on. I just want to make sure I'm not losing track here because as they scroll by me, as more people are asking, I want to make sure I've got everything written down here. Okay, so yes, we have someone who said, let's say there's a business with an in-house legal office, and this business has an enterprise-wide license to like Google Gemini with some privacy and confidentiality protections. What special considerations should the in-house legal team have, and what kind of technical review should they undertake before using Copilot in their own work in-house? Are there attorney-client privilege considerations to make?
So if you're using a paid version, the first and most basic thing is understand their T's and C's, like really read it and see, can I share this data? That's essentially the thing that you want to know. And are you comfortable with that language? Because there will be some permissive language in some of these vendors' T's and C's, which said they may do this, they may do that. And that may be a little bit too flimsy for the protection of what you want, particularly in relation to training data. It's always good to make sure, is that foundational model as the example? And the question was, is that the right one for you? Or is there another one whose T's and C's are more better aligned with your organization? Chanley, do you want to talk a bit about Copilot?
What special considerations should the in-house legal team have, and what kind of technical review or contractual review should they undertake before using Copilot in their own
If
work?
it's something like Copilot, if it's in Azure environment, in all likelihood, the organization has already undergone a technical review, or they've done whatever they're going to do with Microsoft. If nothing's been done, I would recommend, again, it depends on the size of the organization, whether there's in-house security professionals or you need external. But if a security review has not been done, I would recommend it. Now, since it's Microsoft, it doesn't require the level of review that a more or an unknown or smaller vendor would require. For a technical review of Microsoft, as I was started out saying, has probably already been done. And if it hasn't been done, candidly, Microsoft is Microsoft. Okay. You're getting the reason you're going to Microsoft, one of the reasons is for their reputation and their security. Candidly, there's not a lot you probably can do or should do. You can get their SOC 2 Type 2 report for comfort, but it's going to be there. And you, along with 750,000 other organizations around the country, are relying on their security. So you can take comfort in that. And then as far as guardrails, if it's in a secure environment, what we do for our firm is we leave it up, we train and educate not to be reckless with confidential information, but also the reason we have Microsoft, the enterprise license, and the reason we prohibit use of public generative AI solutions is so that we can use confidential information. Now, one important point, I'm glad it just popped in my head. You need to know if you're going to be putting your customer data into any AI environment, you need to have comfort that it's not prohibited by contract. Now, by the nature of outside counsel and probably there are varying restrictions and limitations in some companies either restrict or prohibit outside counsel from using AI, or we need to consult first. And we totally get that on the outside. Within an organization, I would think I haven't seen as much when I'm working on private contracts where one company may prohibit it, but you need to, for your organization, be aware of whether there's any contractual limitations on using your customer data in an AI solution, because even if it's in your secure environment in Copilot, if the contract says don't use AI on our data, you got to honor that, or you got to go back to them and say, listen, I think you probably do want us. We can save X%. We can turn these things around a lot quicker, have a discussion and get that consent.
Other questions?
Yes. So we have someone who said more and more they're seeing AI providers capping their indemnity liability. So they're asking if that is standard for them to do that now and what's reasonable and typical.
I still tend to see things that are uncapped for breach of privacy, misuse of data, breach of security, the traditional ones that you'd see carved out of an indemnity cap.
Yeah, what we see most common is from the customer perspective is a complete carve out of indemnification for IP infringement. So the standard IP infringement indemnification would be excluded from any cap. But we're also seeing more and more a cap on breach of privacy and security or even confidentiality. Now it's probably going to be in seven figures, even for a smaller customer and a smaller vendor, but that's not always the case. What I just stated is what we see most often. So on the confidentiality, privacy, and security, we are seeing more and more of what we would call a super cap. So not completely uncapped, but not 12 months of fees paid.
And then someone else had asked, is it always needed to sign an NDA in case of on-premises AI open source solutions?
Meaning that if you're hosting an on-premises open source solution,
That's a great question. Maybe whoever asked that, if
yeah,
they're still on, can clarify.
I
I'm
I
just
would
pulling it
say
out
if
of
you're
context.
yeah, I would say if you're concerned about sharing confidential information, get an NDA in place.
There you go. Okay, so the last question that we have here is someone often represents small startup SaaS vendors and they can't accept the major shift in liability and risk that the terms we've suggested here represent, particularly when the engagement is for small amounts of money. So, what suggestions do you have for them?
You want to go, Jennifer? Or I mean, I
No,
can
go for it.
start. Yeah, have again with the apologies for the always saying to pick more on the customer side, but I do have a very receptive ear to smaller vendors. If a client customer comes to us and really wants a particular solution, if it's a small vendor and the vendor says, Kate, basically what you just said, the question was, I appreciate and understand that. So what we typically do, and a lot of times I'm the outside counsel, so I'm advising the client, but it's ultimately their call. But there's been many times where I talk to the client and say, listen, for this vendor, for this use case, for this type of data, I've agreed to, or I've had clients agree to, and I have been okay with it, agreeing to the lower limitations of liability. If you agree to that customer, you just need to understand and you need to be sure management understands that the liabilities are limited, the liability of the vendor is limited, but it may be appropriate in this case for this particular solution and just be careful with the type of data you give it. I've been involved in many transactions representing the customer where the limitation of liability for the vendor, even in these areas that we talk about where there's typically carve outs where they end up being capped, either at 12 months of fees paid or something lower than seven figures. I said that's typical. But I think with a honest and candid discussion about why the small, and I've made this argument. Like I said, I do represent vendors and I have some clients that are small vendors and that make the argument. And if you go to the customer, say, listen, we just can't take on this liability. It's would be devastating to the company. And here's the security we have. We we've been doing business for years and never been sued for IP infringements. It's the right thing to do.
I think that's a great answer. Sometimes you just got to make the best of where you are and see if people can just come to a business agreement based on where they are as companies. And that kind of open and honest discussion can often yield an answer that makes both parties happy.
All right, and we have one more question. So, how do you conduct risk analysis for terms within links that contain further terms within other links? And those are updated at the vendor's discretion.
That is always a challenge, and that's where, depending on how important that technology is to you, how important that vendor is to you, is there a master services agreement that can just override all of that? That can be sometimes the easiest solution. And depending on the size of customer you are, you may have that, you may have the ability to do that. Often there's a certain dollar threshold associated with it.
Where we typically end up in a compromise situation is from the customer perspective, agreeing to URL terms, but also saying those terms will not amend the negotiated agreement. So a lot of times URL terms are more for like Microsoft has pages and pages and pages of product use terms and conditions. So tech, and those are incorporated into the agreement. We obviously don't read those, we don't negotiate them. We say those won't amend the negotiated agreement. So that typically ends up being a good compromise as opposed to no URL provisions apply at all, or the URL provisions apply completely. At least have the negotiated agreement prevail in the event of a conflict.
Great. Oh, someone did ask, is there a place that offers cost-effective exemplar AI governance policies and procedures they're drafting from scratch and could just use some guidance?
ChatGPT.com. I'm not aware of an online service that does that. Start with your favorite AI solution and then have it run it by somebody who knows what they're doing.
Great. I think we are past time, and I know we didn't get to every question, but feel free to reach out to Jennifer and Shanley afterward. If you have more questions, please contact them. We've been getting amazing feedback in the chat about what a great presentation this was and how much people learned. Someone is like asking us to do it again so they can absorb even more of it. Just so you know, everyone is
Good.
clamoring that this was very helpful. So thank you so much, Shanley and Jennifer, for coming and being with us today. We really appreciate it.
Thank you.
Enjoyed it. Thanks for inviting us.